Today we're diving into a really unique but incredibly powerful tool in the justice system. It's something that tackles a fundamental question a judge might face in the courtroom.
So just imagine this for a second. You're a judge, there's a case in front of you, and the entire decision rests on one particular law. But you've got this nagging feeling, a serious doubt. What if this law is actually unconstitutional? I mean, you can't just ignore it, but applying a law you think is fundamentally wrong, that just doesn't sit right. So what do you do?
Well, thankfully, the legal system doesn't just leave a judge hanging in a situation like that. There's a formal, structured mechanism built right into the code to handle this very dilemma, all to make sure the integrity of the law is protected.
And that tool is called a reference. You'll find it under Section 436 of the Bharatiya, Nagarik, Suraksha, Sanhita, or BNSS, which is India's new criminal code. What it does is it lets a subordinate court literally hit pause on a case. The judge then drafts a formal question about the law's validity and sends it up to the high court for a final ruling. And trust me, that ruling is way more than just friendly advice.
Now, a court can't just make a reference on a whim. There's a really strict checklist, 5 conditions that absolutely positively have to be met. Let's break down what they are.
So all 5 of these have to be true. First, there has to be a live pending case. And in that case, a real question about a law's validity has to pop up. This can't be some minor point either. It has to be so important that the entire case hinges on the answer. Then, the judge themselves has to be convinced the law is invalid. And, this is a big one, no higher court can have already ruled on it. If there's already a precedent, the lower court just has to follow it. End of story.
Okay, so let's say the stars align and all 5 conditions are met. The judge is ready to make a reference. What does that actually look like? What does the court do next?
Well, the subordinate court has to put together this formal submission package for the high court. And this is not a simple one-line question. It includes a whole statement of the case, a clear declaration of the court's own opinion that the law is invalid, and most importantly, the detailed reasons and legal arguments that led the judge to think that way. Basically, they have to show all their work.
But hold on. While this big constitutional question is being debated, there's a real person whose life is kind of in limbo. So what actually happens to the accused individual at the heart of the case?
The law gives the subordinate court some discretion here. The judge gets to decide between 2 options for the accused. They can either commit the person to jail, keeping them in custody, or they can grant them bail, which would let them be free as long as they promise to show up when they're supposed to.
So, the submission package is sent, the accused's status is sorted out for the time being, and now the whole thing lands on the high court's desk. They're the ones who will give the final, definitive answer. And let me be really clear about this. The high court's opinion is not a suggestion. It's a legally binding order. Whatever the high court decides, the lower court is legally obligated to follow it. No ifs, ands, or buts.
The process from here is pretty straightforward. The high court analyzes the question and issues its binding order. A copy of that order gets sent back down to the lower court, and that court must then resolve the case based on that ruling. The loop is officially closed.
So we've walked through the mechanics, the nitty-gritty of how a reference works. But why? Why does this pretty complex procedure even exist? What's its purpose in the grand scheme of things?
When you zoom out, you see that the reference procedure is a crucial safeguard for the entire justice system. Its whole purpose is to uphold the Constitution by stopping invalid laws from ever being enforced. It creates consistency by having the high court settle these big questions, and it reinforces the judicial hierarchy, which is so important for making sure laws are applied the same way everywhere.
Now, this is a really vital distinction. A subordinate court can't make a reference just because, say, the Bombay High Court and the Calcutta High Court have different interpretations of a law. That's a whole other thing. A reference is saved for when the court believes the law itself is fundamentally invalid or broken, not just being interpreted in different ways.
And, this isn't some brand new idea. This legal safeguard was carried over from the old criminal code right into the new one. What used to be Section 395 is now Section 436 in the BNSS. It just goes to show how essential this check and balance is to the system.
And that leaves us with a final thought to chew on. Reference is an absolutely vital check on legislative power. But the whole process, a process that could end up invalidating a law passed by Parliament, is kicked off by the opinion of a single subordinate court. That's a pretty profound responsibility and a powerful tool for justice.